Session of the Board of Education to order. You can stand and say the pledge.
I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Okay, the first thing on the agenda is the approval of the closed session agenda for September 8th, 2025. Is there a motion?
I'll move to approve the closed meeting agenda for September 8th.
Is there a second?
Second.
Okay, are there any discussion of it? Okay, all those in favor in approving the closed session agenda for September 8th, 2025, say aye.
Aye.
Any opposed? Okay, that carries 7-0. All right, now it's time for public comment. Is there anyone that would like to make a comment? Go ahead.
My name's Ahmed Ismail, and I believe I'm still a named defendant, or claim is a defendant, I guess, in this case. And I would like the ability to sit in the closed session.
That's not a possibility. You're not a city board member.
Well, it's a possibility if the board approves it.
With all due respect, you're not a city board member, and it would be a violation of the attorney-client privilege. Am I correct about that, John?
So we're not going under attorney-client privilege, we're going under pending litigation. So the board does have the ability to invite whomever it chooses in, but they are not sitting board members, so, I'm sorry, Mr. Ismail is not a sitting board member. So it would only, if you're going to let anyone in, it should only be limited to discussions related to how it affects them in a particular case. But it's a board decision who you let in.
Well, I'd like to make a motion to allow anyone named in the case to participate in the closed session silently.
Well, I think it'd have to be just in reference to them. That's what you just said, correct?
Correct.
And would they be subject to the closed meeting
Yes.
confidentiality where it'd be a misdemeanor if they spoke about what they heard?
Absolutely.
I would second that.
Okay, is there any discussion?
Well, just because I'm going to vote against it, I feel like I should explain why. Because these two named defendants have previously spoken about issues that I believe were attorney-client privilege, I don't think it's appropriate to let them hear more confidential information that could be shared, especially because as they're not sitting board members anymore, we wouldn't have any recourse if that information was shared with other parties. So I don't think it's appropriate.
Go ahead.
And they've both been elected trusted officials for Ms. Pappas for 4 years, and for Mr. Ismail, 16 years, was a trusted board member. So I think we could err on the side of their trustworthy.
Well, I'm against it, and I think for reasons that I can't disclose because I think it would violate attorney-client privilege, I don't think it's appropriate for this meeting for either one of them to be sitting in on this meeting. Because whatever we decide is going to be a board decision, not two people that are no longer. We're going to be doing what's in the interest of our district.
Can I ask a question about that? The individually named defendants are also, since they're named separately from the board, they could have a separate settlement as well. So I guess that's a.
Technically they could. We're talking about global settlements right now, and all the defenses are aligned, and including the qualified. Well, I don't
want you to have to get.
Yeah.
What I'm getting at is if the board makes a decision on behalf of the district and the individually named defendants do not agree that that is what they would want, they could then pursue in some other way. Is that correct? Like it's not as if we're making a decision that they would then be beholden to.
Yeah, I mean, I'd rather discuss that in closed session, to be honest with you.
Okay.
Which is another reason why I don't think that it's appropriate for these two people to be sitting in on our discussion about what people are starting to talk about. Okay, so let's do a roll call.
I just would like to ask one more question, and you probably can't answer it. You probably can't answer this one either, but for the discussion that we're about to have, is it possible to parse apart? Like, the subject matter, is it parsable into the individual defendants plus the district as a whole? If you understand.
I think so. Technically, yes, although right now we have aligned defenses. I mean, if you look at our answers and what's been filed.
Yes or no?
And I guess just because they are named defendants that I'm also counsel for, I will have to provide them separate updates outside of the board meeting.
So they would have access to that confidential information anyway.
They'd have access to what the strategy is moving forward.
So I think that's the same question I have, but maybe it's not. It seems to me be redundant that the information will be passed through you to them as clients, correct? So we as a board have to operate under the Open Meetings Act.
Correct.
They are separate clients with an aligned strategy. They would have access to the same information, whether or not they're in this closed session. Is that true?
At the end of the day, they're going to have access to defense strategy, yes.
But the interests of the school district may be separate from the interests of named defendants that are no longer on the board, isn't that right?
It could be at some point. We're not stating it is at this time, but it could be at some point.
So any discussion that we have might jeopardize the district's position if they had access to information.
There could be questions that come up that the board has that could be not aligned with individual defendants. That's possible.
But what I also hear you saying is there'll be a separate bill, so if they don't sit in, they're going to get counsel from you anyway.
I'll provide them an update on what we're doing, and there's a lot of stuff I can't make too many statements in an open session,
But strategy is entirely different than what might be discussed in closed session, isn't that right?
it could be, it depends on the questions that come up.
Couldn't we just kick them out at that time?
The board ultimately controls who's in or out of a closed session.
Could I,
And how long they're in for as well.
could I speak, please, before this goes
No,
on, because public comments hasn't finished.
We're not finished there's a motion on the floor, so no, there's
But
no.
I'm part of
Ms.
this.
Pappas, there's a motion on the floor right now, so there's not gonna be any comments by you right now.
Are we ready to vote on the motion?
Can I ask a question? They would be privy to information based on strategy and maybe outcome of what this might be, but not verbal dialogue of everything that was said, correct?
Correct.
If they were not here. So if they were here, they would have access to that information. Okay, thank you.
Okay, let's do a roll call. Trustee Jeup?
Did we,
Yes.
we didn't second her motion, did we?
Yeah,
Yes, it was
Okay,
seconded.
okay, yeah, sorry.
Yes.
Okay, Trustee Cotton?
Yes.
Trustee Hall?
No.
I'm Colleen Worden and I'm a no.
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 Okay, that motion fails 5-2. Okay, are there other public comments?
Yes.
Go ahead, Ms. Pappas.
So, the idea that two named former board members cannot sit through a discussion of what pertains to them. I have no interest in sitting through any strategies that the board may take. I have no interest in being part of those discussions. But the idea that I cannot sit in a discussion over something that names me personally while I was a board trustee, and let's make it clear, the board is the main part of this suit. This defendant, or this plaintiff, attempted to make use a federal statute, and that's going to be a separate issue coming very soon. But as a former board trustee and as part of this, I should be privy to the discussions of the suit as it pertains to me. I have no problems leaving the room if you're discussing strategy. And just to tie this up, so the idea that you would exclude the two of us from that is really. And I'd like to just address Trustee St. John, because as usual, you're using your bully pulpit to lie to the public. I have never, and neither has Trustee Ishmael, disclosed closed session information. You, on the other hand, a different story. But we were really clear about what confidential closed session meant. And for you to publicly say to anybody or insinuate that I ever betrayed closed session privilege is outrageous and a lie. And you are absolutely disgusting for saying that in your position on the board. That's absolutely outrageous.
Are there any other public comments?
I have one just closing comment.
Mr. Ismail, you were given the floor to make a public comment. This is not the time to be making multiple comments. You were given the floor for one public
You
comment.
should think through what you're doing.
Okay, at this point, I would like to make a motion to enter into closed session pursuant to 8(1)(e) of the Open Meetings Act to discuss pending litigation in the matter of Brush versus GPPSS et al. Is there a second?
Second.
Okay. All those in favor?
We have to roll call.
Oh, I'm
for
sorry, roll
closed
call.
session.
All right, go ahead. Trustee Jeup?
Yes.
Trustee Cotton?
Yes.
Trustee Hull?
Yes.
I am a yes. Trustee Derringer?
Yes.
Trustee St. John?
Yes.
Trustee Klepp?
Yes.
Okay, we are back on the record, and there were no decisions that were made in closed session. So at this point, I would like to make a motion to adjourn. Oh, I'm sorry, are there any other comments?
Oh, from board members.
Okay. All those in favor, is there a second? Okay, all those in favor, say aye.
Aye.
Okay, we are adjourned.